What happened,
Yeah, I'd like to see it soon.
Hi, I'm Erin.
Erin, oh, great to meet
Did you find your parking spot okay?
Yeah,
Perfect. Okay, good. I'm so
Living the
glad.
dream, that's
Yeah.
awesome.
Well, no worries. John, we're ready to start. Nobody
Okay.
else is out in the front.
Great, okay.
Thank you.
Absolutely.
Well, welcome everyone. Welcome to the Wallace Stegner Center. I am John Ruppel. I'm one of the faculty members here at the College of Law, and it's my pleasure to introduce today's green bag. It's entitled RS 2477 Update, the Quiet Title Act and Utah's Biggest Litigation. As many of you may know, in 2012, the Utah Attorney General's Office filed 22 separate lawsuits in federal court claiming title to literally tens of thousands of rights-of-way across federal public lands, or highway rights-of-way. These claims arise from revised statute 2477, an 1866 federal law that granted rights-of-way for construction of highways across unreserved public lands. So collectively, these lawsuits represent probably one of the most ambitious litigation efforts in state history, and we're fortunate today to have Joe Bushyhead from SUA, the Southern Utah Wilderness Alliance, here to talk to us about that litigation and update us on the progress of that litigation. Joe's practice focuses primarily on RS 2477 litigation, because with 22 ongoing lawsuits, that's enough to keep anyone busy. But he's also busy with litigation and administrative practice involving public land management more generally, oil and gas law, planning, and a range of issues. Joe earned his law degree from the University of Oregon and did his undergraduate work at Washington University in St. Louis. He is a relative newcomer to Utah, having worked as a biologist in central Idaho before moving down to Utah. But before I introduce Joe, I want to first of all point out we're going to have a fair amount of time at the end for questions, so I'll turn that over to Joe quickly. But we have one more final event coming up. That will be April 18th. That's Monday here in this room. Our final presentation, which will be the Wallace Stegner Lecture on the Greater Yellowstone Migration Project. We're fortunate to have Joe Reese, who's a photographer from National Geographic Magazine, and Arthur Middleton from the Yale School of Forestry and Environmental Studies. Arthur and Joe will share their story behind the traverse of the Greater Yellowstone ecosystem, following one of the most iconic residents of Yellowstone National Park, the elk, on its annual migration from Wyoming's ranch land into America's deepest wilderness. We hope you'll be able to join us for that spectacular conclusion to this year's programming, and with no further ado, I'll turn it over to Joe.
Well, thank you to the Stegner Center. It's a real privilege to be here, and thank you all for coming. We've got a pretty good turnout, and that's, I think, something I'm pretty happy to see, because if I had to give a natural resource issue a more innocuous sounding name, I don't think I could do any better than RS 2477. But this is a hugely important issue, especially in Utah. And it's given rise to what the Utah Attorney General's Office calls the biggest litigation effort ever undertaken by the state. These are 26 related cases. They've since been consolidated down into 22 cases in federal court, and they seek to claim title to 12,500 approximate individual rights of way across federal land. It's a suite of litigation that, if successful, will do more to frustrate federal land management and especially conservation goals than really anything outside of an outright land transfer. I'll talk about this litigation in some detail, but I want to start with some backstory. And I want to start just briefly talking about the organization I work for. I work for the Southern Utah Wilderness Alliance. SUA's mission revolves around America's Red Rock Wilderness Act. This is legislation first introduced in Congress in 1989 by Utah Representative Wayne Owens. It's been introduced in every Congress since, and as it's been currently introduced, it seeks to protect nearly 9.5 million acres of BLM wilderness through designation. This includes places like Lockhart Basin in San Juan County. It includes places like Desolation Canyon on the Green River, really iconic landscapes. These are the Badland Cliffs viewed from the West Tavaputs Plateau. So SUA has been playing defense on these lands for about over 30 years now, really with the end goal of ensuring that these landscapes maintain their wilderness eligibility, protecting them from development threats. And really since the beginning, one of the biggest threats has been RS-2477. So I want to jump into it, and this is RS-2477 in its entirety. The right-of-way for construction of highways over public lands not reserved for public uses is hereby granted. That's it. We don't have much legislative history on RS-2477, but this was passed as part of the 1866 Mining Act. This was in a time of the Homestead Acts, Preemption Acts, of westward expansion. And it's fairly widely recognized now to be a statute that facilitated that westward expansion. I really see RS-2477, as I've come to understand it, as really two separate stories. The first is really began when Congress passed the statute in 1866. And it's really sort of a remarkably unremarkable story. RS-2477 was on the books for 110 years, and in that time it would pop up in the courts rarely and usually in property disputes and disputes between a private person and a property owner. It was mainly raised as a defense to trespass. But apart from these limited court cases, this is a statute that really wasn't controversial. The second RS-2477 story, and this is the one we're in now, it has been far more eventful, far more exciting, and far more controversial. It begins in 1976 with the passage of the Federal Land Policy and Management Act. This is the comprehensive governing law for lands managed by the Bureau of Land Management. It replaced a policy of land disposal with one of land retention, and it really had two key issues for our purposes. First, it repealed RS-2477. It recognized valid existing rights of way, and it replaced RS-2477 and a host of other congressional rights of way grants with Title V, which is this unified permitting scheme for both new and existing rights of way. Second, and I actually really think more importantly, FLPMA subjected BLM lands to the 1964 Wilderness Act. This specifically, it required that BLM inventory roadless areas and recommend areas as suitable for wilderness designation. The suitable lands would be protected as wilderness study areas and managed to protect their wilderness values. The wilderness inventory, for those of you that know the history of it, it was a huge deal in Utah. The BLM manages nearly 23 million acres of land. That's about 42% of the state. I talked recently actually with a retired BLM staffer who told me that he'd lived through two cultural revolutions. The first, he was a graduate student at the UC Berkeley in the 1960s, and then after that he participated in the wilderness inventories in Utah in the 1970s. And to understand that, The goal of conservation and the idea of wilderness in Utah, and especially in 1976, was really deeply controversial. The BLM really for the first time was considering wilderness character as a resource to be managed alongside things like oil and gas and mining, and the agency pushed back. The original wilderness inventory was deeply flawed. The BLM fast-tracked the process from 15 years to 2 years. The BLM then proceeded to conduct a review that was really the definition of arbitrary. It set initial caps on the amount of lands that it would recognize as suitable wilderness. It made arbitrary boundary distinctions to either eliminate or reduce the size of roadless areas. It used the potential for mineral development as a means of excluding and negating wilderness suitability. And this was all in direct violation of FLPMA's mandate. In the end of the nearly 900 roadless areas that the BLM first identified, it disqualified about 90% of those lands as wilderness suitable. I'll do a quick little side note here. This wilderness inventory was really the genesis of SUA. SUA was a direct response to the flawed inventory. Shortly after, and this continues today, SUA and other conservation groups used the BLM's own guidance documents to conduct a re-inventory, and SUA has presently identified roughly 9.5 million acres of wilderness-eligible land in the state. So, the passage of FLPMA and the wilderness inventories also provoked the Sagebrush Rebellion, which was a push in the other direction. This was against federal management, against conservation mandates. And in Utah, the Sagebrush Rebellion really almost immediately latched on to roads in RS 2477 as an offense, as a way to go on the offensive, to push back against the perceived threat of wilderness designation. These photos were taken in 1980 outside of Moab in Grand County. The county commissioners organized a protest and bulldozed a road into Mill Creek. This was to try to disqualify the area from wilderness designation. The photo on the bottom right is the protest itself. This was on the 4th of July. The photo on the top left was actually taken a few days later. The county realized it didn't hit the WSA boundary, went back in to hit that. I'll do a quick little side note here. These photos are from a really excellent book by Jedediah Rogers called Roads in the Wilderness. I'd recommend it to anybody who wants to take a really deep dive into the history of RS 2477. So a colleague compares the Sagebrush Rebellion to a cicada hatch. About every 8 years when we have a Democrat elected as president, it rears back to life. This is a 1999 protest in the White River proposed wilderness unit in Uintah County. Uintah County illegally graded a road into the unit. The photo on the top left is actually House Representative Chris Cannon. He helicoptered in for the rally and then sort of made a big show of hopping into a truck to drive the newly constructed route. As I think anybody who follows the news in Utah knows, the Sagebrush Rebellion hasn't gone away. We're currently in the midst of Sagebrush Rebellion version 3, I think. And roads in RS 2477 are really still a flashpoint. These are photos of San Juan County Commissioner Phil Lyman's protest ride in Recapture Canyon. This was to protest a BLM motor vehicle closure to a trail built illegally in 2007. Commissioner Lyman, at his trial last year, tried to defend his trespass under the theory that the road was a RS 2477 highway. So if you want to take Sagebrush Rebellion ideas and you want to make them law or to test them in the courts, the surest way of doing that is really to enlist the state of Utah. In 1978, the legislature tried to formally recognize RS 2477 claims by enacting a statute that created a new classification of what are called Class D roads. This is a catch-all category for any route constructed by use and that doesn't receive maintenance. The law also required that the counties map all their Class D claims by 1980, and that's what we have here. This is a map prepared by Garfield County. In 1993, the Utah legislature passed an act, a very comprehensive act that really dealt with a lot of issues relating to RS 2477, and these are things like scope and planning requirements. And this was a response to a proposed congressional rulemaking in 1993 that never happened. The proposal was controversial. Congress in 1996, as a result of this, actually forbade the Department of the Interior from promulgating any rules on RS 2477. That prohibition stands today. The state legislature continually amends this act. It was first passed in 1993, but it's seen a number of revisions as a way to both keep up and push back on federal case law as it develops. Utah was also home to some of the first RS 2477 litigation. One of the first was the Burr Trail case in Garfield County. This was Garfield County seeking to pave the route and citing RS 2477 as the authority to do so. This eventually culminated in the 10th Circuit's decision in Sierra Club v. Hodel. It bears mentioning, too, that Professor Bill Lockhart, who's actually here with us today, really broke a lot of new legal ground on this and other cases on behalf of conservation groups. So after Burr Trail, there were a few small RS 2477 cases. Washington and Millard County both brought relatively small cases and didn't win on either. But the biggest flare-up really happened in 1996, after President Clinton designated the Grand Staircase Escalante National Monument. The monument protected 1.9 million acres of wildlands from a number of very imminent development threats, the biggest being Andalex Coal's proposed mine on the Comparowitz Plateau. A few months after the monument designation, Kane, San Juan, and Garfield counties began bulldozing a number of rough tracks both in and outside of the monument. And they cited their authority under RS 2477. This photo is of Dan Kent, an activist protesting grading on Hart's Point. This is just east of Canyonlands National Park. SUA sued the BLM to take action. The BLM then filed cross-claims against the county for trespass and violations of FLPMA. That lawsuit culminated in 2005 with the 10th Circuit's SUA v. BLM decision. And I want to talk a little bit about this case because it's really the seminal case that we have right now. And it was actually authored by Judge McConnell, who taught here. It's a long opinion with really a very limited holding. The holding is that the courts and not the BLM are the ones who decide the validity of RS 2477 claims. What that means practically is that any RS 2477 claim has to be brought under the Quiet Title Act, which is the very limited waiver of sovereign immunity, the United States' sovereign immunity, for suits involving title to land. The 10th Circuit, though, really went on and very broadly discussed sort of the history and the contours of RS 2477. And one of the most important results from this case is the test for determining what makes a valid RS 2477 claim. This is the test that the state and counties must now prove in litigation to succeed on their claims. And it's 10 years of continuous and uninterrupted use of a claim as a public highway before either the land was reserved or FLPMA's passage in 1976. The SUA v. BLM decision set the stage for sort of what I consider to be the test case era of RS 2477 in the 2000s. In 2004, San Juan County filed a quiet title action claiming a 12.3-mile route through Salt Creek in Canyonlands National Park as an RS 2477 highway. As you can see, this is the claim itself. Salt Creek is a perennial stream. It's host to the densest concentration of archaeological sites in the park, and it also very famously leads to the Angel Arch, which is pictured here. The Park Service had closed the stream bed to motor vehicles because of riparian damage, and the lawsuit, the resulting lawsuit, first resolved in 2011 after a 9-day bench trial, after a helicopter tour to the park. The district court found that the county didn't establish the required 10 years of continuous use to prove its claim. In 2014, 10 years after the case was first filed, and this is on one claim, the 10th Circuit affirmed the district court. The next case was a quiet title action brought by Kane County in 2008. This is what's referred to in shorthand in our world as Kane 1. This was an action brought in for 15 roads involved in the 1996 monument grading protest, and many of these roads were relatively uncontroversial, maintained gravel roads. The county did include what's pictured here. This is the North Swag route. This is one that was very much of concern to us. It runs through the Paria-Hackberry Wilderness Study Area. This is a photo from a site tour, actually, in advance of the litigation with SUA, attorneys from the United States, the county, and the state. This is the very stuck truck you can see of a Kane County official trying to show everyone in attendance that this was a passable route. In 2013, the district court resolved 12 of the 15 routes in favor of the county. In 2014, the 10th Circuit reversed as to 6 of those routes. So, in 2011 and 2012, the state and most of its counties really went orders of magnitude beyond any of the test cases that had happened so far. And this is what we're dealing with now. These were 26 coordinated lawsuits in federal court. They've since been consolidated into 22. The state and counties are seeking to quiet title to 12,500 claims. These amount to roughly 25,000 miles of road. Each red line on this map is a claim. When we overlay these claims onto designated proposed wilderness in orange, we can see the real threat here. Now, over 10,000 of the 12,000 plus claims are these Class D routes. I mentioned earlier, this is the catch-all category created in 1978. It includes unmaintained 2-tracks, wash bottoms, trails. And this is a claim in the Fiddler Butte proposed wilderness in Garfield County. It's very clearly just a wash bottom. I want to do a quick note. I showed the Class D maps that the counties had been required to produce in 1980. Some of the current claims are on those maps. Many are not. We've interviewed county commissioners and officials as part of pretrial discovery, and many of these current claims were actually mapped for the first time in the 1990s, 10 to 20 years after RS 2477's repeal, and this was done by county commissioners and employees using GPS on ATVs. This is another claim near the Bull Mountain proposed wilderness, or in the Bull Mountain proposed wilderness, and near the Henry Mountains. This is another claim near the Henrys. This, I think, is fairly typical. A user-created 2-track, measuring maybe 7 feet wide. For each of the 12,000 plus claims, regardless of current on-the-ground size, the state and the counties are seeking a 66-foot wide right-of-way and the ability to grade and surface that right-of-way. That's the equivalent of a 4-lane highway. Zooming in, this is Parunaweep Canyon. This is just east of Zion National Park, and it's really an area that's as spectacular as the park itself. The wilderness study area is indicated in orange with red hash marks. The yellow hash marks indicate areas that the BLM has subsequently recognized as having wilderness character. The numbered lines you can see are road claims, and for the most part, the largest of these, the Class Ds, are 1 vehicle wide. Now remember that, for each claim, the state and the counties are seeking a 66-foot wide right-of-way. That would radically change the character of the land. And I think for the state and the county's purposes, it would disqualify the area from wilderness eligibility. I want to quickly address one of the state and county's rationales for bringing the lawsuit. And that is that these claims, these RS 2477 claims, connect communities and schools and stores. It's an attempt to, I think, take RS 2477 out of this very contentious wilderness debate. And I think the state likes to highlight claims like these. These are Class B roads. Class B roads are roads that receive regular maintenance, and they really do form a large part of the transportation infrastructure in rural Utah. But there are 2 points I want to make, and that's that, first, that these Class B routes represent about 1 in 6 of the total claims. The second point is that these are claims for which there's no dispute, and thus no jurisdiction allowing the court to decide the validity of an RS 2477 claim. I want to talk a bit more in detail about this disputed title issue because it's really at the front burner of federal litigation right now. For you lawyers in the room, this is where you'll earn your CLE credit here. The Federal Quiet Title Act is the only vehicle by which the state and counties can bring their lawsuit, and it sets strict parameters for claims. Subsection A limits the claims to those that the U.S. actually disputes. It's similar to the Article 3 case or controversy requirement in federal court. The Ninth and the Tenth Circuits, the 2 circuits that have looked at this language, have both held that a cloud on title isn't a dispute. Instead, the U.S. must take some action that actually conflicts with the state or county's claim title. The clearest example in the RS 2477 context would be closing a road. These critical roads, the Class B roads the state and county maintain now, simply aren't in dispute. The BLM has never taken action to dispute really the vast majority of the 12,000 plus claims. The state recently served jurisdictional discovery on the United States to try to find things like internal agency emails to try to gin up a dispute. We're at the motion to dismiss stage right now in 2 active cases, and I think we're expecting a big fight by the state to try to keep every claim in. As it stands right now, though, under 10th Circuit precedent, most of these routes are not even justiciable in court. That leaves claims like these, which are the most ominous from a conservation standpoint, the claims that are clearly an attempt to disqualify an area as wilderness. So beyond the consequences to wilderness and to land management, these cases are really noteworthy just for their sheer volume, the sheer size. According to the Attorney General's office, this is the largest litigation effort ever undertaken by the state. By the state's own reckoning, which I now think is optimistic, the litigation will take almost 20 years to resolve. It's been almost 5 years since the state first filed its cases in 2011. All but 2 have been stayed. The 2 active cases are in Garfield and Kane counties. Those are in the motion to dismiss stage, and we're still awaiting rulings there. The lawsuits are also very expensive. There's no way around this. The Utah legislature last year appropriated $3.3 million for the RS 2477 fight. That's an annual cost we can expect each year that this case drags on. To try to deal with the scope of litigation, the federal court who's dealing with these cases has initiated what's termed a bellwether process that's going to start in Kane County. The parties will select 12 routes to be driven to a mini trial. This is an attempt to bite off a more manageable chunk of the lawsuit and to really try to resolve some of the many, many unresolved legal questions surrounding RS 2477. It's a process that all the parties support. I think there's a very real chance, though, that with 12 routes, it's simply not going to resolve this real host of legal issues or the very unique factual circumstances surrounding each claim. I want to talk quickly about SUA's role and some of SUA's efforts in this litigation. SUA was granted intervener status in the federal litigation, and we've been an active party, but we've also taken the lead on litigation in state court. In 2014, we paired with a Tooele County resident and wilderness advocate named Michael Abdo to bring a state court action, and it's challenging the authority of the Attorney General to bring the statewide litigation in the first place. Section 78B2201 of the Utah Code expressly prohibits the state from bringing a quiet title action more than 7 years after the state's right or title to the property accrued. RS-2477 claims are somewhat unique in that we have a date certain by which all claims must have accrued. That's October 21st, 1976, when Congress passed FLPMA. Our assertion in the case is that the Attorney General acted ultra vires. This means beyond his authority in bringing the RS-2477 litigation. It's both to protect wilderness and to stop what we see as a real waste of taxpayer money resulting from what's illegal litigation under state law. So when we filed our case in 2014, the state very quickly removed it to federal court to try to fold it into the larger litigation. We successfully got it back to state court, but the federal court actually enjoined the proceeding or stopped it from happening. It's a fairly remarkable result and one we appealed to the 10th Circuit. The 10th Circuit heard argument in January, and we're expecting a decision probably any day now on that. In the meantime, the federal court certified the question of whether the statute at issue in ad novi reis is one of limitations or repose. So what this means is that the federal court asked the Utah Supreme Court to answer this question on the basis that the operation of the statute, of the state statute, would be dispositive to all claims. This is a really weedy distinction, this repose versus limitations issue, but it's essentially asking whether the statute started running automatically on accrual of the state's title, or whether it didn't start running until some cause of action was created, whether the state was put on notice of some sort of dispute. That question was argued in front of the Utah Supreme Court a little over a week ago. So, what does the legal landscape look like now? Right now, RS-2477 is in front of three courts. As I just mentioned, the certified question is before the Utah Supreme Court. The state court case is presently enjoined, but the appeal is pending in the 10th Circuit. I think either the certified question or the state case, should the injunction be dissolved, could resolve the litigation in relatively short order. The bellwether process continues to move forward. The court still hasn't resolved pending motions to dismiss. And I think even though this litigation's been pared down, to what we anticipate to be 12 routes, this is still a federal court case bound for trial. The Salt Creek case, for one route, took 10 years to resolve. I think we're probably years from any even initial decisions. Apart from these court cases, the Utah congressional delegation is trying at every turn to put RS-2477 into legislation. Rob Bishop's Public Lands Initiative, of which the delegation released a draft, would give away thousands of RS-2477 rights of way. Representative Chris Stewart put a very flagrant RS-2477 giveaway into a defense bill. This is for the Utah Test and Training Range in the West Desert. California Representative Cook, recently introduced a very bad bill that would essentially rewrite the rules of RS-2477 that we've gotten from courts over the last few decades, and would essentially potentially rubber stamp claims across the West, not just in Utah. The bottom line, and this is, it's a conclusion, but this litigation is really, I think in many ways, just starting now. We're years from resolution, but we've got some very, very important cases coming down the pike. We're still, I think, right now working through a lot of threshold questions, a lot of very initial preliminary things like jurisdiction, the Quiet Title Act, sovereign immunity. We really, I think, are close but haven't even gotten into a lot of the very meaty substantive questions about what makes or doesn't make a valid RS-2477 claim. So with that, I'd like to thank you all for coming, and I'd like to open this up to questions. go ahead. And we've got a microphone that's going to circulate around here.
What are they doing to preserve the witness pool? Because your witness pool is now 60-plus years old. In order for the state to prove its case or not, or to challenge that proof, to get that 10 years of proof before 1976, is there an effort, and how are the courts approaching the preservation of these witness testimonies that person may not be available in 10 or whatever years it takes to get that to court?
Yeah, well, you've actually probably hit on one of the biggest parts of this litigation that I really haven't even discussed. This is something that I'm very involved in. A number of attorneys here are also involved in, and these are preservation depositions. Going back to the SUA v. BLM test, for the state and counties to prevail on their claims, they needed to show 10 years of continuous public use before 1976. At the very latest, that would be the period between 1966 and 1976. These witnesses, witnesses to that time period are, elderly, to say the least, and there's been a big effort to conduct what are called preservation depositions. This is, we're traveling the state collecting deposition testimony from witnesses. But I think the big issue really here is that we're collecting testimony that is decades old. We're collecting memories from 40, 50, 60 years ago. But this is a big effort. I think there have been well over 300 depositions conducted so far. I think we're looking for the opportunity to really test and see what that deposition testimony, how much weight it actually holds in court. We'll get you the microphone here, sorry.
On your initial RS-2477 map, it looked like there were no claims on national forests. Is that true?
That's right, and I'll go back to that here. So, RS-2477 operated until 1976. Before that, RS-2477 would stop operating once lands were reserved. Reservation is the process in which the federal lands start as sort of the open public domain, open to things like homestead acts, mining claims, things of that nature. The federal government can then reserve lands and devote them to a specific reserved use. For the most part, Forest Service lands were reserved in many cases at the turn of the 20th century, in the early 1900s. And this, there have been claims of RS-2477 rights-of-way to Forest Service land, but it really comes down to a burden of proof. It's practically impossible to prove to satisfy the evidentiary burden going back 120 years or more.
Is the Attorney General's office handling all this litigation with its own resources, or does it hire outside counsel?
So the Attorney General's office has a big team, no question. That's the Public Lands Policy Coordinating Office is really heading this up for the state. Most of the FLPCO folks are Assistant Attorney Generals, Special Assistant Attorney Generals for the AG's office. Kane County's been a really active litigant, both from the start, from the bulldoze first ask later sort of phase of this. They have outside counsel, and there's sort of continually efforts in the legislature. Representative Mike Noel is one of the big proponents of this litigation. He's from Kanab, that's his district. He's constantly getting the state to reimburse Kane County for its outside private legal help. They have, yeah. The question was whether the county's been successful in being reimbursed. They have been. They were reimbursed. I'm not going to give the specific number. I can't remember it, but it was either this legislative session or the last. Yes, I think that an appropriation went through for their outside counsel. Yeah. Well, we'll see. The 3.3 number was the highest I've seen yet, and that was for the 2015, this past, it was the legislative cycle just before this last one. I haven't followed the appropriation cycle for this coming fiscal year, but I'd assume so. It's well north of $1 million for the litigation effort, well north of $2 million for the litigation support and mapping and things of that nature. Good.
Can you tell us a little bit more about the bellwether process? How are the 12 routes being decided on, selected? What's the mini trial that's going to happen?
Sure. So the bellwether process was really sort of started out of the district court, the three judges who were at the time presiding over the active cases, really seeing this volume of litigation and needing a way to engage it and actually start deciding claims. This process started with issues memoranda. These are issues, memoranda submitted by the party to identify sort of the big ticket issues that the parties think will be dispositive on a greater subset of claims. We're at that point now. The district court is weighing these issues to resolve, and after that, the parties will then select what they consider the best routes to really test these legal questions. The federal court will be the one to ultimately pick the routes and ultimately sign off on those routes. That's something we're expecting soon.
Would you discuss the issue that you proposed about the 66-foot right-of-way and to the extent that that's been addressed by the courts? I know the Burr Trail litigation dealt with the off-site impacts of the road and the width of the road, and the earlier cases dealing with RS 2477 roads limited widths to the type of uses. So is that still a boogeyman out there, or is it really a legitimate issue, or has that been narrowed somehow? What?
Yeah, so I think there have been a number of decisions, starting with the Sierra Club v. Hodel decision, dealing with sort of the scope of the right-of-way and the allowable activities within that right-of-way. I'm fairly optimistic that 66 feet isn't going to happen for most of these. The court in the Kane County 1 case actually set a 24-foot wide right-of-way, and that was using federal highway standards to come up with sort of an arbitrary number. That width determination was rejected by the 10th Circuit and sent back to the district court, but we're still waiting to see. We'll have remand proceedings imminently. I'm actually sort of surprised they haven't happened yet, regarding the width and the nature of the right-of-way in Kane County.
I'm just curious, has there been an effort to identify D-class roads that are not a threat to wilderness areas and take them out of the litigation?
That are not
on proposed wilderness on study areas. I mean, it seems to me that there must be some D roads that there's really not an argument about.
That's gone both ways. There have been claims that are just, absolutely egregious, and claims that I don't think the parties, that the U.S. certainly hasn't disputed, and that certainly SUA wouldn't dispute. That winnowing process to either flag routes for potential resolution or to kick out routes that are clearly egregious hasn't happened yet.
I have a history question for you about how we got to the Class D roads. Because going back to 1850, again in 1880 and 1921, for a county or the state to claim a road, they had to file either with the court or with the Department of the Agriculture, and that doesn't seem to be part of this case anymore.
No, it isn't. It's interesting that some states, Wyoming's a big example, they have recording requirements in state law, and that's really done, I think, a lot to sort of stave off these kinds of lawsuits, where you don't have a recordation. they can't go forward under state law. In Utah, there's certainly requirements for recording, but RS 2477 has been interpreted to be a self-effectuating grant, an open offer of a grant of right-of-way. And in Utah anyway, in the SUA v. BLM decision, which really looked at Utah law, there hasn't been this recordation threshold or requirement, not here in Utah. So, that may be something that comes up later on as these issues get fleshed out. As I mentioned before, we're really, I think, just starting to sink our teeth into a lot of these really meaty issues, and any lurking issues of state law will probably come out then.
I have a couple of questions. First, just a political rant, I guess, really, which is the name of the Policy Coordinating Committee strikes me as a little strange. Are they coordinating any kind of policies other than going after these roads?
Is this the Public Lands Policy Coordinating Office?
Yeah.
Yeah, they are, and they a few of them are here. I think the RS 2477 lawsuit is a huge component of their work. They're involved in for sure other administrative appeals and things like that. I mean, it's really the state of Utah's sort of official line in federal land management. Which
then I have a question about the text of RS 2477.
Sure.
The continuous use element and the highway element both are left, of course, undefined. But my question really has to do with interrupting ownership. So the reserved lands are all over the state in little chunks, and I would assume that many of these roads transect those reserved lands, and if they are reserved, the lands in question preclude the determination of a 2477 right-of-way. Is that descriptively, that is, are there a lot of these roads that do cross those single reserved tracts?
Yeah, absolutely. This gets to reservations, these federal land withdrawals and reservations, and we have a few decisions already from the SUA v. BLM decision. We have a decision on coal withdrawals. We have a decision in the Kane County 1 decision case on public water reserves. But those are two of many different types of reservations,
right.
And those are being teed up in the bellwether process right now. I think all parties have identified reservations as a big issue.
So the question of whether the interruption of the continuing highway is precluded because of the presence of those state sections has not really been ultimately addressed in the litigation to date?
Well, so state sections are a bit of a different issue. So, state...
I'm sorry, yes, I misspoke. Okay. Yeah, I'm talking about the reserved sections, of which there are a great many.
Yeah, that's really one of these big areas that's just this sort of wide open unknown. This very new area that we're really going to be pushing and exploring in the coming years. No question.
Are any of the bellwether roads involved in that?
They will be. The bellwether roads haven't been selected, but the issues have been proffered to the court, and absolutely, one of the very unanimous issues is this one of the effect of reservations, different types of reservations, things of that nature.
Thank you.
I think I read in the paper that Salt Lake County withdrew all of its RS 2477 claims. Can you discuss what that was and how that happened?
I'm not sure if Salt Lake County ever brought RS 2477 claims. Somebody in the FLPCO office might be able to nod or shake their head, and I don't think they have. one of the big issues has come down, one of the big drivers for all this litigation has been the Utah Association of Counties. This is, a group that's really driven by rural counties, and this is, if you want to see the Sagebrush Rebellion pushed in an organization, it's UAC, it's the UAC. There was some recent controversy. Salt Lake County gives money to they're a member of the Utah Association of Counties, and there was some controversy recently, I can't speak to it in much detail, over Salt Lake County seeing its money being used to push this, very anti-wilderness, anti-conservation agenda that really goes against, the constituency, especially here in the Wasatch Front. And I don't. Oh. There are, yeah. The Natural Resource Defense Council, Sierra Club, the Grand Canyon Trust. We're all aligned, and I'll use this to mention too that this is a huge litigation effort and a huge task for all the parties. We've got a relatively small office. We have 5 attorneys in Salt Lake, but we've been able to enlist pro bono help from a number of large law firms, large national law firms, and we also have assistance from some just awesome firms here in Salt Lake who are helping us with this huge defensive task. I think we may be out on time. Maybe we have time for one more.
Make it quick.
Sure.
Well, isn't the UAC the one that named Phil Lyman the Commissioner of the Year? And here we are in Salt Lake County, and we pay more into it than anybody. And I'll try not to say a bad word about that guy, but to me, that's just phenomenal. Isn't there something we can do as a county to say, hey, don't do that?
Yeah, that's right. It's an interesting. That controversy, I think, is interesting in the way it sort of ties in all these issues going wrong right now. The official frontline fight for RS 2477. The very, very active Sagebrush Rebellion version 3 that's happening right now. It's one of those things that's sort of characterizes this dispute and this sort of battle over roads that's been going on for decades. Yeah, with that, thank you all very much for your time. I really do appreciate the chance to talk.